Will the Scottish Executive say whether it will introduce the practice of allowing a McKenzie's friend into law courts?
Kenny McGaskill.
The term McKenzie Friend refers to the practice in English and Welsh courts where parties are given assistance from someone other than a lawyer in presenting their case in court. At present, a party can be represented by a friend, relative or lay representative, such as a Citizens Advice Bureau representative in the small claims and summary cause sheriff courts. This covers actions up to a value of £5,000. The Right Honourable Lord Gill's Civil Courts Review is considering the issue of McKenzie Friends. I look forward to receiving his report, which is expected in June of this year, and I will consider carefully all of his recommendations about McKenzie Friends and wider issues about those representing themselves in courts. These wider issues include the funding of court actions, improved court procedure and other methods of dispute resolution.
Margo MacDonald.
I thank the Cabinet Secretary for his reply and his attention to Lord Gill's upcoming report. But he will also have before then, I think, the petition which was lodged just 2 days ago. And I should draw it to his attention that the McKenzie Friend system, which we advocate, would not allow anyone to advocate on behalf of any other person in court. They are simply there to advise or support someone who may be without legal representation. As such, I think he must agree with me that that will only enhance the procedure in the Scottish courts.
Cabinet Secretary.
Well, I do believe that anything that makes people more comfortable in a court environment is to be welcomed. There does have to be a majesty of the court, but court can be traumatic in whatever it is, and therefore the ability of people to have some support is important. What, as I say, is of more and greater complexity and has to be looked at and around is the question of those with formal representation rights. Clearly, as I say, we have addressed them at small claims and summary level. There are the ability in some instances in debt cases, in ordinary actions for representation to be there. We have broadened matter with the Association of Commercial Attorneys now being given various powers signed off by the Lord President. But there is a broader matter that has to be looked at. The one thing I can say that differentiates Scotland from England is that we do have wider and broader access to legal aid here than south of the border, which does mean there is greater opportunity for representation. But as I say, this is a matter that I do think Lord Gill has to, as I say, consider, because it's not simply about the comfort and the ability to be assisted, whether it's by a lay or legal representative in court. It's whether court is the appropriate place and forum for that matter to be dealt with. And that's why these matters, I think, should be dealt with in the totality. And I look forward to Lord Gill's review and will be more than happy to discuss the matter thereafter.
Question 6, Ross Finney.
To ask the Scottish Executive